Title VII covers two areas: racial discrimination and racial harassment. Now, the notion of race has expanded. I mentioned that the definition, the idea of race, has grown from what it was back in the 60s, which was essentially black and white, and we've expanded on the notion of race. That race has entered this era in which ethnicity and race have sort of merged, and so we no longer think of two or three races, but in fact dozens. On the 2000 census, famously, the choice for racial classification, you had 23 different choices to make in terms of racial classification, and in fact you could only check one box. Now, we consolidated that a bit in 2010. The 2010 census listed approximately 12 racial groups, and you were allowed to choose more than one in an effort to determine race. But of course, this has meant that the statute, Title VII, has expanded to cover many more people or many more issues than was originally intended. Remember that prima facie case that we talked about. The first thing you have to prove is membership in a protected class. And you have to prove that you were treated differently than a member outside of your protected class. So in a racial discrimination claim, it's necessarily going to involve establishing that you were of a different race than the person ultimately selected for the job. Now, how do we do that? Now, the EEOC has provided guidelines to determine what race is or how to ascertain race. And so it uses a number of factors to help guide the decision. So they'll look at things like ancestry. Where were your ancestors from? What race did your ancestors consider themselves? Obviously, physical characteristics are important in racial classification. What do you look like? Race-linked illness, where illnesses that are unique to one race that can establish your link to that race. Also, culture. What is your culture? What is your cultural background, your cultural heritage say? Perception. Not what do you think of yourself, but what do others think of you? That could lead to a claim of race discrimination. Association. Who is it that you associate with? What do those people consider themselves to be in terms of race? So establishing race, which at one point seemed to be a pretty straightforward issue, has become much more difficult. And in fact, the idea of what is race? Is race ethnicity, or is it something different? Well, courts have struggled with that. This case that I have mentioned here, this Alonzo versus Chase Manhattan Bank, involved an individual who originally filed a discrimination claim, and he checked the box of a national origin discrimination. Mr. Alonzo was Hispanic, and he brought a claim against his employer on the basis of national origin discrimination. Now, while the charge was pending, while the claim was pending, Mr. Alonzo changed the classification of his lawsuit from the national origin discrimination to racial discrimination. Race discrimination receives the highest scrutiny, so it is to the advantage of anyone to make their claim into a race claim if they can. Now, in this case, the court looked at the issue and the question was, is Hispanic a race? Or is Hispanic mean ethnicity? And the court was really reluctant to get into the issue of what is a race, what is simply an ethnicity. And so the court said, let's just see how this thing works out. And they allowed the claim to go forward as a racial discrimination claim, despite the fact that it historically would have clearly been a national origin claim. So when we get to national origin discrimination, we'll talk about one of the one of the things that we've seen in national origin discrimination is a trend in bringing national origin claims, historically national origin claims, as race claims. Now, Title VII prohibits discrimination on the basis of race, which means it puts obligations on employers. And every employer must ensure that every employee has an equal opportunity, regardless of race. As I said, Title VII is going to protect blacks and whites as in the same way it protects men and women, in the same way that it protects Mexican Americans and Czech Americans. Now, employers, of course, have to be careful to guard against subtle manifestations of race discrimination, and we'll talk a lot more about that when we start talking about in more detail about disparate treatment and disparate impact claims. Now, a case of racial discrimination can be established by disparate treatment or disparate impact. Now, disparate treatment, remember, that involves treating people differently based upon their protected category. I treated this person differently than this person. It involves individuals. So disparate treatment can be shown by direct or indirect evidence of discrimination. Disparate treatment involves intent. Disparate impact can be more difficult to discern. Disparate impact, remember, can even be negligent, in which we have a neutral rule, a neutral screening device that is designed to help us make employment decisions, but that neutral rule has an adverse impact upon people in a protected class. So disparate impact is harder to determine its existence. We know that race cannot be used as a BFOQ. Therefore, on your test, if there's ever a claim about racial discrimination, and one of the answers is the defendant can assert a claim of BFOQ, you know that's wrong. The framers of Title VII made it clear that what they envisioned was a world where race simply didn't matter, where a person's race had no impact upon his or her future opportunities. It involved the context of being colorblind, of not just simply not taking it into account. And now there's a lot of debate about whether that's even possible or whether that's even something that we want to achieve. But we know that the framers of Title VII wanted to create a world where race simply didn't matter. And therefore, they added this specific provision that race could never be a bona fide occupational qualification for a job. Now, color. What is color doing in there? Well, at the time the statute was passed, the best guess is that color was meant to simply be a synonym of race, that there really was not a distinction between race and color. Nevertheless, it's in the statute, and the way we've seen it used has to do with actual skin color, and therefore this comes into play in terms of intraracial discrimination. In this case, Walker versus Secretary of the Treasury, it involved an IRS employee who was a light-skinned black person. Her boss was a dark-skinned black person, and she believed that she had suffered discrimination as a result of the difference in skin tone. So she brought a claim. Now, she could not bring it as a race claim because they were members of the same race and therefore would be unable to establish that prima facie case of disparate treatment depending on that you were treated differently than someone outside of your protected class. But the court says, well, this is what color is for, that if we are going to make decisions based on skin tone, even apart from race, then that is also illegal. So there's not been a lot of cases on color, but you know what that means is it has to do with intraracial discrimination.